guilty.
Now, when you were arrested, were you released on bail or were you
I
kept in?
was. No, I was. I was released on $50,000 bail. I was fortunate. So at the time, my mother was in a long term relationship with a local businessman who was Jackie Keegan, and so
Okay.
he was somewhat of a father figure in certain respects, and
Hmm.
that's how I was able to get bailed out. I mean, we certainly didn't have the means for me to get bailed out absent that.
But you had a legal aid attorney
I
or a
did.
public defender.
I both. Yes.
Okay.
Yes, I had the legal aid attorney. That was the public defender. Yes.
Right. Okay. Now, at some point, uh, did they try to work out a plea deal, or did you say I didn't do it? So I'll
Yeah.
have to go to trial then.
I didn't do it. It was only at the end, after the summations had been completed and the jury got the case, and before they came up with the verdict, the prosecutor made an offer. He offered me 5 to 15.
Not before that.
Not before that. No, no, not before that. No, I was adamant that I was innocent, and also remember that the DNA didn't match me.
Wow. Right.
So that was supposed to be the centerpiece of the
Did
defense.
you feel pretty good going into jury deliberations?
I did. I did feel really good about it. Sure.
Okay. And then verdict comes out, and you're standing there next to your attorney.
Hmm.
You get weak in the knees when you hear guilty more than once.
They allowed me to remain seated rather than the typical standing up.
I see.
That having been said, so the jury's coming out, and I remember this jailhouse saying that people had told me. They said, "Well, look, when they reach a verdict, try to make eye contact with the
Right. They're looking
jurors.
at you. It's
They're
not
looking and
not
smile. Or
guilty.
if they're right, looking at you and smiling, it's
I've
not
heard that
guilty.
one.
But if they look away and they're stone
Hmm.
faced, they've convicted you. So I'm looking at them and they're looking away, and
Hmm.
but then I'm thinking, but no, they can't be. I think that that's saying they don't know what they're talking about because I'm innocent. I'm going to be found not guilty. And they read off the first three charges, not guilty, and then suddenly I hear guilty, guilty,
So you got lulled
guilty.
into a false sense of security.
Yes, I am. And when I heard guilty, I think, well, wait a minute. Did I just hear that right? Did I
Hmm.
miss the word "not" on the front end?
Your mother was in the courtroom.
She was.
Did you
So
get a
she
chance?
wrote. So she kind of like, when she heard the not guilty, the three not guilty, she like kind of like jumped up in court with the arms out, almost like you might do at a sporting event.
Sure.
And suddenly to hear
Hmm.
guilty, 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 you know,
The murder, rape, and
yeah,
did you have a chance to see? Well, did they let you turn around? Because some courts they're like, "Don't turn around. Don't look at the gallery." Did you get a chance after the guilty verdict was read for you to see your mom's face?
I did. I
What was
did.
that like?
I never got that question before. She had like a sunken, ashen uh, disbelief on her face. Like none of us saw that coming.
And I bet you just wanted to hug her at that moment, and you couldn't.
I did. In fact, I even I even foolishly asked the court officer, could I sit with my, mother and my aunt, and obviously that wasn't allowed.
They polled the jury, right?
They did poll the jury.
And they all
Sure.
said consistent with
They
the
all
ultimate verdict.
they all said guilty, guilty, guilty 12
What
times.
was, and in fact, this was not even on my question list, but what was your first night? Because you had been out,
I had
right?
been out.
What was your first night in jail as a convicted individual?
Yeah, it felt like it was not quite real. It felt
Surreal.
it felt surreal. It felt scary as well. Like I didn't know really what was going to happen to me next. And then remember, I'm incarcerated for a sex offense, and there's a vigilante mentality towards people
Sure.
who've been convicted of sex offenses. So, and I'm in an adult county jail, and I'm 17 years
17
old.
years old.
And I'll be candid with you. I was frightened.
I could imagine anybody. I don't care if it was a big biker. You're in jail. You're away from your family. You don't know if there's going to be protection, to protect you, and it's just I can't imagine. I've had this discussion with Marty Tankleff, and very similar. You're frightened. You don't know what to expect. Did your attorney come back there right away after the verdict?
No, he did not. No, I didn't see him for several weeks after that when he came to discuss sentencing.
So when you were convicted, you had to anticipate the sentence was going to be a rather lengthy one,
Yes,
murder and rape of a young girl.
of course.
So
Yes.
you had no preconceived notions going in. And what was the sentence?
The sentence was 15 to life. So
15. Could have been
yes,
25 to
could
life.
have been 25. Could even have been 30. had the judge
Okay.
been so inclined. But yeah, but 15 was the minimum, and that's what I got.
Yeah. Now, how long after that you get sentenced that an appeal? Obviously, you were thinking about that once you were convicted, of
Of
course.
course, that's the first
You
thing
don't have
that
to be an attorney to
one
think
of
that.
one of the first things that goes through your mind. Of course.
Now, when did that take hold? Let's say where somebody was representing you in an appeal.
I want to say maybe like a couple of months. I mean, I as soon as I got back to the jail
Hmm.
after the sentencing, I yeah, mailed the form, as
Right.
for the appeal. So I mean, I got that thing
You don't want
going
to miss
as
the deadline.
yeah, I got that thing going as soon as I could. But at that point, there was like a backlog in the courts, and then more money was needed to be appointed, legislature, the
Right.
governor, and the end result of it all was while I was sentenced on January of 1991, my appeal was not decided until 1994.
Wow.
So that was really a rather lengthy time period.
Okay. So obviously you lost the first appeal, and you
I
lost
did.
a number of
I
them.
did. I wound up losing 7
Right.
appeals. Yes.
So you lose the first appeal. Now, did your attorney say, "Look, if we lose, we're going to go to another court," or were you prepared to lose that appeal, or were you confident?
I was confident.
Okay. And why were you confident? Because the DA didn't the DNA rather didn't match.
That was part of it, but beyond that, the my lawyer had sent me the copy of the brief, and so I went up to the law library and started looking up all the authorities and case law that was cited in
Hmm.
in the brief. And as far as I could tell, I mean, all the
Yeah, you felt you had a
cases
strong case.
felt I had a strong case. Yeah,
Hmm. Now, how many appeals did you lose,
7.
and how spread out were they? So you lost the first one.
Hmm.
When was the next
The
bad
next
news you got?
the next bad news I got was approximately 2 or 3 months later.
That quick?
Yeah, well, it was a re-argument motion,
I see.
which was denied, and then more bad news approximately maybe like 3 months after that, which was leave to the Court of Appeals was denied.
Right. Highest court in the state,
Right.
and denied. Huh?
That was denied. Yes.
Now the next appeal you did.
Yeah. The next.
What changed? How was it different than let's say the first one or two?
Yeah. So there was a about 2 years of legal inactivity, and then the next proceeding was actually technically not an appeal. It was a habeas corpus
I
petition.
see. Produce the
Which
body.
Yeah,
That's
right,
right.
of course.
The
But just
Latin.
but just for our viewers, the difference between that and an appeal is that state law issues are irrelevant in a habeas corpus proceeding.
Hmm.
It's all about whether you can demonstrate a constitutional violation.
Okay. Were any 440 motions made?
There were no 440 motions made. No.
Okay. That's what got Marty cleared.
Yes, it was because
440.
the 440 is post conviction motion is the
Right.
correct vehicle when you have some new evidence. But at this point, I don't have new
No
evidence,
new evidence.
so I have to continue to argue the issues that are already on the record.
But you were cleared because of new evidence, weren't you?
I
Because
was
so there was
further
still no
DNA.
440
There was at the end, but
at the
we're
end.
not there yet.
Got
Let
it.
us walk through this
Sure.
since you mentioned. So I lost the habeas corpus petition. That's in 1997, but I lost because the court clerk told my lawyer the wrong information pertaining to the filing procedure, and as a result of that, my petition arrived 4 days too late,
Okay.
which
And the DA at the time was
was
Janine
Janine
Pirro.
Pirro. Yes, and her office took the position that those 4 days were prejudicial to the people, and therefore
How?
the court should simply rule that I was late.
Like I said, if I was the DA, you want the truth, because if you're not the guy who did it, and the guy who did it is out there, and look what happened. When
Exactly.
was that? When did he kill again?
He killed 3.5 years later. So we lost the habeas corpus petition at 97. Now we're up to 4 legal proceedings that have been
Okay.
lost. That decision was then appealed to the Federal Court of Appeals, where the 2 judges hearing the challenge on the procedural issue,
Hmm.
just at the lateness we mentioned,
Right.
was Judge Rosemary Pooler and future U.S. Supreme Court Justice Sonia
Oh,
Sotomayor.
okay.
So my lawyer argued that this was not a delay caused by me or my attorney, but by the misinformation by
The
the court
clerk.
clerk. That upholding that ruling would cause a miscarriage of justice to continue, and that reversing the ruling would open the door to more sophisticated DNA testing. So once again, Piro's administration opposed the appeal, and the court ruled with the DA. There was a re-argument motion with a request for en banc,
Hmm.
all the judges on the
All the
circuit
judges. Right.
to hear it and make a decision. And that was denied also by those same two
But
judges.
what was the rationale for the ruling against you by the court?
Because EDPA had been passed, the AEDPA Act, the Anti-Terrorism Effective Death Penalty Act, had been passed, which stated that all state prisoners would have 1 year to file in federal court after being denied by their state's highest court. And the theory of the legislation, though misguided, was that we need these cases to be streamlined, we need it to be more timely, we need to put a limitation on them, and so and that was all inspired, of course, by the Oklahoma City bombing with Timothy McVeigh.
Right.
Okay, but that had the fallout of affecting cases throughout the country, even mine.
Who
Because
would have thought something like that would affect you?
yeah, who would have thought that? And the other thing I want to quickly mention about EDPA, aside from putting like the 1 year deadline on, and by the way, they don't appoint a lawyer. There's no right to an attorney in a habeas corpus petition. The court can discretionarily appoint one, but that's only after the petition itself and the memorandum of law have been filed. So now you're asking someone who's not a lawyer,
To do it.
poorly educated,
Wow.
to do it. But then on top of that, um, it's EDPA has a layer of deference built into it. So it's not enough to simply that the state court was wrong, but
Right.
their decision has to have been unreasonable.
High bar.
A very high bar.
I see.
So I lost at the Federal Court of Appeals. The only thing left is to seek cert from the U.S. Supreme Court, and of course they declined to grant me cert. So now all my legal remedies are out. I'm 11 years in prison by now. We're in like 2001, 2002. So at that point, the only vehicle left for me is the 440,
40.
but I have to have a basis for that. And I start this letter writing campaign because we didn't have any money to hire an investigator or an attorney to try to dig for new evidence. And certainly I wasn't going to find any new evidence
Not
behind
not
bars.
behind bars.
Not behind bars. Right. So we wrote letters. I wrote letters for 4 years, and eventually one of the letters found its way in the hands of an investigator, and she convinced the Innocence Project to take my case.
They did.
And they did. And here's what they did. Here's the difference, okay? Because the Innocence Project, they took the crime scene DNA evidence. And by now, Pirro had left office, by the way.
Okay.
And she was actually in the middle of her attorney general run. And as I understand it, the backstory is so her successor, former Westchester DA Fiore, they didn't like each other.
Right.
And so she was hoping that I would be exonerated to impact her attorney general run.
You'll take it.
I'll take it. I'll take it. Yes. Yeah. So they
Wow.
took the crime scene. So getting the Innocence Project representation was the first key. Second key is Pirro left office. Third key is the crime scene DNA evidence, which already didn't match me. It was put in the data bank, and it matched the actual perpetrator whose DNA was there because, as we mentioned, he killed a second victim 3.5 years later. So it matched him, and confronted with that evidence, he admitted that he committed the crime, and he also admitted to a reporter on video camera. So to be clear, no false confession there.
Now, while this process is going on,
Mm-hmm.
did there come a time, and I know you had to have obviously your down moments, that you gave up where you figured, I'm never getting out of here? Not within that. And you still served an awful long time. But
I
did you
did.
think you were going to be there for a long, long time?
Along the way, I did not. I thought I just had to hold on for a year or two until the next proceeding. I kind of lived from appeal to appeal, which I was sure I was going to win the next one because I was innocent and I
Right.
believed in the system. I really struggled with not giving up in my last year because I had lost the 7 challenges. I wrote letters for 4 years, rarely got responses other than the occasional no. I went to the parole board. They slammed the door shut as well by denying me. And I thought that at that point, I really struggled in that last year. I thought I was going to die. I thought I was going to die in prison.
Now, we had talked a little bit before the show started about a Brady violation, which is Brady is the DA has a legal obligation to turn over anything that could be considered exculpatory, in other words, tending to clear the defendant, or could be used for impeachment for cross-examination purposes. And often, it's very common that there are violations of this Brady material. In your case, how did that affect you?
I learned about the Brady violations in the course of pursuing compensation. So I learned, for example, that the medical examiner had been complained of in neighboring counties by law enforcement. He was moonlighting as a defense expert, so he was working on helping people get away with crimes.
Still a conflict of interest there.
A little, yeah,
I
you
would
think? Yeah. But could you imagine giving false testimony, getting complaints
No.
about it, but then not turning that over. So that certainly was a huge issue. But we never learned that until discovery in the lawsuits. Ironically, and this ties into one of the legislative reforms myself and my colleagues we helped to pass. Uh, Group it could happen to you, a statewide coalition was discovery reform. So my argument was that I had more discovery rights as a plaintiff pursuing a lawsuit than I
Right.
did as a defendant defending myself against the false charges.
Yeah,
We use that argument
right.
rhetorically to help usher in discovery reform.
Well, my old co-host, in fact, Frank was on a few weeks ago. That happened. Now, he didn't, you know, wasn't there for murder or anything like that as serious as yours, but we didn't get a lot of information, he and then me, until the civil case, because then the criminal case is over. They're not as guarded. Like I said, some clerk is making a copy of the file, gets it to you, and then your attorneys, wait a minute, we never saw this the first time around. But when you were exonerated, it was because they had the database. That didn't exist in 1990, or that?
No, it did not. No, the DNA technology at that point was RFLP, and that allowed law enforcement to compare DNA from a crime scene to a particular suspect.
Knowing
The
no database. That
No,
was the
yeah,
difference.
that's yeah, exactly. There was
Right.
no database, and the database was filled of DNA profiles of people who had previously been convicted of
Mm-hmm.
violent crimes and who currently were convicted of violent
Okay. Now, along the way, when did you think about? When did you toy with the idea of becoming an attorney?
crimes. Yeah,
Because
so
first you're trying to save your butt.
right,
But when did
exactly.
you think about, if I get out of here, I want to be a lawyer?
That was in my 14th year of
Wow.
imprisonment, and I remember just sitting there right in front of my cell bars and just feeling very frustrated about everything. And I just kind of wistfully said to myself, if I get out of here, I'm going to become a defense attorney and I'm going to help exonerate other people in the same position as me. But honestly, it was kind of a wistful thinking. It was almost kind of like if you metaphorically are walking in a graveyard at midnight
Mm-hmm.
and you start whistling.
Right.
That type of that it was that type of thing. Didn't seem it was that realistic at that point. But yeah, that's a great thought, Jeff. It's never going to happen. You very well may never get out of here the way this
But
is
it's something
going.
to keep you going,
It is.
and something to strive for, because, again, you're an innocent guy.
Yes.
So you got to believe at some point, look, there's a God up there. I didn't do it. Somehow, some way, it's going to be shown, and I'm getting out of here.
You always hold on to that hope. Yes, that was. And I want to share that at some point after about 5 years after I was exonerated, I was financially compensated. I want to take the individual advocacy work that I had done, speaking, writing,
Right.
uh, meeting with elected officials, doing media interviews, doing all that for about 5 years as an individual advocate. But when I was finally compensated, I used some of the funds to start Jeffrey Deskovic Foundation for Justice, and we got the results that you mentioned. But the point where I'm going is that at some point I became tired of sitting in the front row of the courtroom.
Right.
I wanted to be able to sit at the defense table and represent some of the clients, make some of the arguments. So, had my first success overturning a conviction as a lawyer this past December, serving as co-counsel to fellow Long Islander Oscar Michelin, who's an advisory board member of the foundation. We overturned Andre Brown's wrongful conviction, who had been in for 23 years, and
Wow.
a couple of weeks before Christmas, so he was able to spend that with his wife and his kids.
Now, how was your foundation? Obviously, you were successful, but why wasn't that individual successful in his efforts prior to your entity getting involved? What did you do that made the difference, your entity?
Well, so first of all, Oscar had been with Andre for 4 years before we entered. So we entered the case in the last year and a half of its pendency during efforts to over.
Okay.
So Oscar spent like 5.5 years with Andre, 4 of which were without me, and the last year and a half with me. So I think the difference is that, well, as far as what we added, so I was able to draft some legal documents. So I remember once when Oscar had a timing conflict and he couldn't file a
Mm-hmm.
response at the same time as he had another obligation on a different case. So I
Right.
said, "Listen, let me draft this, and you look at it, and then
Mm-hmm.
about 85% of what I wrote made the cut of what he ultimately submitted to the court. But I also assisted in the evidentiary hearing. We got that, and certainly the media aspect of it. We did some press conferences and some media. We packed the court, and the documents that I didn't draft that he drafted. He really didn't have an ego, and this is like a man that's like exonerated like 9 people. You could say you could have an ego. Look, just sit back and learn. But instead, he allowed me to review everything he was doing, and I made a bunch of suggestions for improvements,
Okay.
which most of which he
Another set of
incorporated.
eyes.
Another set of eyes, and certainly bringing stuff from the innocence policy world in
Okay.
as well, and a lot of that improved the brief.
Now, in that particular case, what made the? I know we were talking a little bit about what
Mm-hmm.
you guys brought to the table,
Mm,
but what piece of evidence or pieces of
yes,
evidence cleared that man?
yeah, it was several pieces of evidence. So first of all, uh, we found the alternative suspect, okay, who was a spitting image of Andre. That person
So there
was
was ID identification in that case.
what's that?
There was ID identification. It was identification.
Yes, it was. Yes, there was an identification.
Very unreliable.
Very unreliable. So here's the rundown. We found the alternative suspect who was a spitting image of Andre. Second of all, that individual was ID'd by two other people whose names already appeared in the record. So they didn't surface at the 11th hour.
Okay, right.
Their names were in the record before, but the trial attorney had not been able to find them. Then that was corroborated by ballistics evidence. And here's the kicker, Phil, is that Andre's trial attorney never presented crucial medical evidence. Andre had been shot a year before in an unrelated incident and had surgery, so he was unable to run. So the actual perpetrator
And that never was
descended.
brought out.
It was not brought out at trial, but it was mentioned in the record. So Andre had started out with one attorney, and that attorney alerted the court that that was going to be what the defense was, and yet this other lawyer never presented. In fact, it was the only Thomas Lee is his name, the defense lawyer,
Okay.
was the only lawyer, as far as we know, in U.S. history to have entered the witness protection program as a result of being in-house counsel for the Bonanno crime
Oh,
family.
really?
So he had his own legal difficulties at
I
that
see.
point. So every one of those things was the part of the evidence that our 440 motion was based on. But despite the conviction being overturned and Andre being released on an ROR, the Bronx DA's office is still appealing that decision.
Still.
Yeah, I mean, look, if you can't run, we not only found medical evidence, but we located the actual surgeon who did
Hmm.
the procedure, and he said he had drop foot. There's no way he could have pushed off to run. So the actual perpetrator descended a Bronx subway, ran about 4 blocks faster than the two victims, a double attempted murder, caught up to one, shot one, turned and ran down another approximately 4 or 5 blocks, and shot a second person.
Why? It's unfathomable to me that the attorney and what you're saying is so obvious that he couldn't have done it.
Correct.
Was it incompetence? What caused the attorney not to introduce that evidence?
I I think he was just distracted by his own legal problems, which
All
we know,
right.
which obviously hadn't been
Right.
disclosed. But even so, and by the way, one of the I wanted to mention the IDs because we talked about that. So there was two people misidentified Andre. So one person claimed to have saw the victim and Andre pass run by while she
Right.
was in the car. But the problem with her story is that the street that she said it happened on is not the street where the crime happened on. She claimed to have been seated behind a red light in her car, and there
Right.
actually is no light there. There's a stop sign, but no light. And it's like a brief couple of seconds. So that's the problem with the first ID. And the other ID is the second victim claims that as he's running and he got shot, which that had the impact of severing his spinal cord. So he claims that as he got shot, as he's falling, he was able to turn his head and glance back
Okay.
for a couple of seconds, and that's the
So one guy
IDs.
was killed, one guy was injured.
No, there was no, neither one was killed.
Oh, okay. Just
It
two
was it was two
severely.
severely injured. Yeah, double
Got it.
attempted murder. Two
Got it.
attempted murders.
Okay. Now, when you said 13 people were exonerated because of your
Well, it was
foundation.
13 people that were freed, but let me get into the numbers. So
Okay.
four of them are exonerations. The other one, the fifth one, Andre, we don't count as an exoneration because the appeal's still
Still
pending.
pending.
Okay, now the other people, so if any of our clients come up for parole
Right.
once we're working on their case, we try to get them out on parole so that they can be free, albeit under supervision, while we're working on exonerating them. But we were able to get 5 people on parole. We sent a letter to the parole
All
board
right.
outlining our primary and secondary reasons why we believe that they're innocent. Another person was going to an evidentiary hearing. The hearing had been awarded, and the Pennsylvania Attorney General said, "Look, you can fight this out if you want. Maybe you'll win, but we won
Right.
once. Or you can go home. You can go home a couple of days from now. Do you want to? But you got to take it out an Alford plea. Excuse me, nolo contender, not an Alford, a
Okay.
nolo
Which you don't have
contender,
in New York.
which we don't have. Right.
California has it.
This is a PA. Yeah, this is a
Right.
PA case. So that's another person got home that way. So we were one of the 5 entities that could collaborate on that case. And lastly, um, the last person, we were actually working on we were trying to get DNA testing. Actually, he was a Long Island case, but he had been determined to be terminally ill, and so the fact that we were working on the case,
Right.
reinvestigating it, we incorporated that into the compassionate release application, and so that resulted in him being released.
A question: the Nolo contender plea
Mm,
in Pennsylvania,
yes,
did that prevent him from suing?
of course,
That's what I'm. That's what I figured.
yes.
So that's their way of protecting the taxpayers in a sense, because he can't. Yeah, I'm getting out, right? And it's not even like he's in a sense convicted of anything because it's a Nolo
Well.
contender.
He is still convicted of something because the conviction remains intact. You have a criminal record, and just to
Yes.
quickly mention, I mean that was a Brady violation that was being litigated. So first of all, and by the way, the defendant's name in that case was Lorenzo Johnson. So the newly discovered of the Brady violations and newly discovered evidence in that case was that the sole ear witness, not to be confused with an eyewitness, um, was an alternative suspect, and that had never been disclosed.
Okay.
The motive witness,
Clearly a Brady violation.
clearly, the motive witness had a quasi familial relationship with the lead detective's mother. That had never been disclosed. And then there was several hundred pages of documents that were supposed to have been turned over. So we feel like he would have won that. We would have
But
won the
time was not
case.
on his side. You said he
Time
was
was not
ill.
on his side. It was a 5-way collaboration. We were on the primarily the public relational, but we did some investigative work. But the other entities, doing the lawyering of it, were located in Pennsylvania, and we told him to
Hmm.
keep going and clear your name, and everyone else told him to take the deal, and he wanted to also get back home to
Sure.
his elderly mother who wound up passing away not that long after that, so he did get to spend some time with her that he might not have gotten. But the other detail I wanted to mention, which went into Lorenzo's decision, is he originally did 16 and a half years before a habeas corpus petition was granted
Right.
on legally insufficient evidence grounds, which is tantamount to a not guilty verdict. But that was from the Third Circuit Court of Appeals, but the Pennsylvania Attorney General's office appealed that decision to the U.S. Supreme Court, and they reinstated the conviction after 4 months.
The U.S. Supreme Court did.
Yes,
Wow.
they granted cert and reinstated the conviction all at once. I mean, they'll never do that for a defendant, give a revert. But
Hmm.
anyway, that resulted in him having to return back to prison to resume a life without parole sentence because that's what it
I
is
see.
in there. And he stayed there for 5 years. I mean, we had a great investigative plan. We collaboratively all put together, and we just started hitting wall after wall after wall after wall. It looked really grim at one point, but ultimately, the end of 5 years, he wound up coming home.
Okay.
Other evidence was found. We were going to the hearing, and then
Sure. Now, when your foundation gets a case, do you find that you usually team up with an attorney that's been with the guy for, or the woman, depending on, been with the person for a while?
not usually. Usually, the team up is with a new attorney
A
that
new
had
attorney,
a new attorney. Yes,
not the trial attorney, an
not definitely
appellate,
not the trial
right?
attorney,
But
and not
appellate.
the appellate. Not typically not the appellate attorney either. Their appointments only last for the state appeals, the direct appeal,
I
and
see.
the leave app to the Court of Appeals and litigating the Court of Appeals if you get in. But we usually team up with either a lawyer that's with someone already, not for the appeals, but who came aboard. So either then, but the more or the other way it could happen, and this happens a little bit more frequently, is we reach out and we partner with lawyers also.
Right. Now, how does a case come to your foundation?
We get a letter.
Someone writes you.
Yes, snail mail. Although occasionally
Someone in
friends and
jail or a family member?
well, it's someone in prison writes the letter. But occasionally we do get an email or even an inquiry through social media, and that's done by family members or friends or advocates that are on the outside.
And then what is the process that you, because obviously not everybody is
It's
innocent.
innocent.
So
Correct.
how do you assess? You don't want to waste your time
Right.
when you have limited resources.
Correct.
So what do you do?
We vet and screen the case. I'll walk you through the process really quickly.
Sure.
So, I guess at the bottom line of it is we ask ourselves two questions: Do we believe the innocence claim, and is that based on something objective, and that involves us taking into account what was used as evidence to convict? And we know what the a lot of the red flags are based on DNA exoneration. So we know what red flags are, that an ID might be mistaken, a confession,
Sure.
false, an informant lying. So do we believe the innocence claim? Do we see a potential route to exoneration? The legal standard is, would this new evidence probably have resulted in a different outcome?
Got it. So that's what you do.
That's what we do.
In some cases, you tell the person, sorry, we can't help you.
Yes. Yeah, we reject far more than we accept.
So then you accept. Then what do you do? All right. So we said
Mm-hmm.
meets the standard. Now what?
Actual work on the case is going to begin. So, in the part of the assessment process, as I mentioned, is the viability of exoneration. So now we're actually going to hit the field. So, we look for things like alternative suspects, look for similar crimes in nearby areas, file a FOIL request. There might be document. But another thing also is any other new witnesses that have bubbled to the surface not previously available. Do we re-interview witnesses who we think were not truthful the first time around? And also, if the presence of a character whose misconduct has bubbled to the surface in an unrelated case.
I
So
see.
those are all, we start playing those investigative lines, and you start pulling on the
Mm-hmm.
yarn, you see what else happens. And that's all in a non-DNA case.
Sure.
But in a DNA case, it's much more straightforward. Is there something that could be subjected to DNA testing? Is there hair, spit, saliva, blood? Is there a clothing item that has been sweated into? And then we would just, it's at that point, it's just get the item tested.
Okay. And who is on your staff?
Yes. So I have a part-time office administrator. She's like doing the back end of it. So she supervises our interns and our volunteers. Another Long Islander, actually, Charlene Gachette. So she deals with the correspondence, sending the application out, and then also her and the interns, they're collecting the documents so that there is something to analyze. That's then sent out. We have 3 volunteer case analysts that are off site. So the completed file is sent out. They read the underlying materials. They fill out forms, which I then read for me to wrap my head around the case without having to read the original underlying material.
Right.
And then we once and then I suggest different inquiries. I've read several hundred cases that have ended in exoneration, so I know the routes that people have
I
taken.
see.
So I say, well, what
Common
about
themes.
common themes? So I run the common themes out to the case analysts, and they let me know, does that applicable to that case as something to look into or not. And after doing that 2 or 3 times, eventually we've turned over all the rocks, and now we know all we can. And now we make a critical discussion: do we going to approve the case or are we not? And we decide things by consensus. So if we're going to close, we have to consent. We have to be in consensus. If we're going to approve, has to be in consensus. So that's my way of guarding against us accepting a case that where someone is not innocent or
Like
there's no way to win.
like a jury, unanimous.
Yes, yeah, yeah. There we go. Absolutely.
You got it. Now, where do you get the volunteers? Are they law students, college students? What are they?
The interns are college students, so some are law students, but more often they're in undergrad.
Mm-hmm.
The case analysts are volunteers, so 2 of them came from Centurion Ministries, so that's the country's oldest innocence entity. So they were doing case analysis then. Another person was a book author, was and is a book author with several books on wrongful convictions in print. One of them was called Framed by Google Maps.
Mm-hmm.
And once it's approved, then one of my board members is an investigator. So he does some investigative work, but we also partner with outside attorneys. They're all looking for a good case, meaning
Right.
where someone's innocent, there's a way to win, and there's a possibility of civil litigation after the fact, and that's where they would
I see.
make the financial part of that.
Do you find that it's easier with a high-profile case where people have heard about it than in a case that's not high-profile?
Yes, I do
Because
find it
people
that
come
way.
out of the woodworks. You might get a like like with the OJ case, those attorneys, so much fell into their lap.
Yeah, that's true. That's true. Yeah, I do find that I do find it's a little bit better that it is better with a high profile case. You know, we were talking offline
Right?
earlier. We talked about Long Island's Marty Tankleff case,
Yes,
and
who's been on my show as well.
yeah, sure. But the setting up of the tip line, the publicity that Lonnie Sori from Sori Communications, the PR firm, was able to do, and that led to a lot of tips coming in,
Right.
which were ultimately ran down by the by Marty's investigator, and that is actually what
Hmm.
formed the body of evidence that went into Marty's 440. So that's an example of how
I
high
read that
profile.
440 motion. Very interesting. Now, what about the media? What role? We were talking about high profile, obviously, media, but how how has your relationship been with the media on these kinds of cases?
It's been good. So firstly, the media crucified me when I was a defendant. Okay, with a lot of prejudicial pretrial publicity with virtually all the articles from a guilt presumptive oriented
Sure.
perspective. But the media has been great to me since then. And look, my name and look, having a master's degree and with my thesis on wrongful conviction, cause and reform, being a lawyer, being having had the successes, both I have a reputation, I have credibility, and so I think that that comes into play when I seek out media attention. But I also have plenty of facts on the case. I mean, in terms of even forming my own opinion, I don't do that lightly. I have a ton of primary and secondary things that I go into, so I'm able to marshal and be really concise in laying things out, and that's all part of the pitch to the media.
Now, these men, is it any females?
Yeah, there is one female. So I have a high profile client you might have heard of before, Carolyn Warmis.
Oh, yes, I
From the
have.
yes, from the so-called fatal attraction case in Westchester.
Yeah.
So we're in the process of finishing up DNA testing.
Yeah,
And
Diet Doctor, was that the?
no,
That
no,
was a
no, no,
different
no. The
one.
Scarsdale diet. That's
That was
Betty Jean Harris.
okay.
So
Got it.
yeah, yeah. So this is a different case, but that was also high profile in Westchester. Yeah. So she's a client, and we were able to secure DNA test. That was the case where my entering the case got her the testing because uh, her prior attorney, another Long Islander, this Long Island theme continuing, Dennis Kelly, who the foundation brought into the case. We screened the case and then we pitched it to him, and he took the case. And then when I got my law license, he reached back around and said, "Look, we'd like you to re-enter this case, but as an attorney." So they had the Westchester County DA's office had opposed DNA testing, and that was the subject of an appeal. And the
Why did
night
they? What were they opposing?
Yeah, their opposition really didn't make any sense, but they were opposing it, and so uh, it was the night before the case was going to be orally argued in the morning by Dennis at the appellate division, and we got word. But I had reached out to the DA, because I had supported her as a candidate, and she ran on a justice reform, wrongful conviction prevention and correction plank, which had an item in it that you were gonna not fight DNA
Sure.
testing. So, and I reached out to her, and then the night before the appeal, really really late at night, she sent word that they were dropping their opposition. They
Okay.
were consenting to that. But I don't. But I'm giving that as an example. I think if I was not in that case, that would not have happened.
I see.
They would have continued. So there's an example of the high profile
Do you find
work.
that? And again, you're on the defense side, obviously.
Hmm.
That it almost seems like the prosecutor, no matter what you want, you say up, they say down. You say left, they say right. Is it their job, or do you find that no matter what you're trying to do, you're trying to find to exonerate this person? Do you find that their positions sometimes fly in the face of either logic or getting at the truth?
Yes, sometimes. Well, certainly in the Andre Brown case, like I referenced before, that made no sense that we had to litigate that case. It makes no sense that there's an appeal going on, considering that wealth of evidence that I referenced. So that there has been some of that, yeah. But at the same time, though, my foundation, we like to try to we if a district attorney's office has a conviction review unit, which
Right.
is supposed to be an independent unit within the
Suffolk
DA's
has that
office,
now.
right? So we like to try to reinvestigate cases with the district attorney's office. So we fill out an application
Right.
and we outline why we believe the client's innocent, and and of course they want to know, well, what
Right.
how can we verify this innocence claim? What are the lines of
Right.
investigation? So we like to go that route, and so with those units, we found that I found so far for them to be open minded. I mean, I have about 6 cases right now in different jurisdictions where I'm co-counsel, where we're proactively investigating the case with the district attorney's office. But
But
I know at some point in it's just a matter of time before one office or another, just refuses to reinvestigate, or they start with something that doesn't really make any sense logically. I know at some point it'll happen. I haven't had that happen yet. Again, I think that my having the body of work and being high profile and
not
having
everybody
been
has that.
exonerated, I think that you're right. They don't, but I think that that's an X factor that works for my. But they know I'm not going to represent. So I'm not. I'm not a defense. I am, but I'm there for innocence. I'm
Right.
not there to
A
cause a
hired gun,
reasonable.
let's
I'm not
say.
a hired gun. I'm not there to create reasonable doubt. I'm there because I think the lady, or the
Right.
guy is innocent, and I'm trying to prove that. I think that's a
Right.
big difference between myself
I
and
do.
just a.
And these offices, these DA's offices, are aware of your vetting process.
They're aware of
It's
the
not just
vetting.
somebody,
Yes,
I got paid a lot of money and I'm going to bring this case.
right. No, they're aware of the vetting process, and they know who I am. I'm a very vocal advocate. We talked about the policy stuff before, so I do media all the time, and I'm involved in working policy changes. I mean, the from videotaping interrogations, identification reform, DNA database expansion, commission on prosecutor conduct, discovery reform. I was very the foundation, my foundation through my work, um, partnered with many other organizations and advocates, and I've been rather vocal on all of these
Mhm.
different. So I do a lot of media, and I do a lot of new media, and so they know who I am, and they know that they know I'm an advocate. I'm not just an
Right.
exoneree. I'm that's my backstory. That's what motivates
Yeah,
me.
street cred.
But yeah, there we go.
To put it in the vernacular.
To put it in the vernacular.
But it's great if an office has a bureau that, let's say, looks at those kinds of things, because you think it would make more sense for you to deal with that bureau than any other entity within that office.
Yeah, of course.
But what offices, let's say, don't have that in the tri-state area, or do they all have it now?
No, they all don't have it now.
I
So
didn't think so.
so no, so we have the 5 boroughs have it. Westchester County has it. Nassau and Suffolk do. But as you
Right.
start to go, hey, like Putnam County
It's a
doesn't
newer
have it.
creature in Suffolk County. They didn't have that years ago.
Right? Yeah. Well, I mean, the DA was
Right.
corrupt and went to
I think
prison.
Ray Tierney started it, DA Tierney. But that's a good thing to have, because again, you want to get at the truth.
Mhm.
And if the wrong guy is in jail, like I remember when I had Marty on my show, he said something I still remember to this day. He said, when you read the paper and it says, "We arrested so and so for the murder of this," and people, "Oh, thank God." He says, "No, you got to ask yourself the next question: Did they get the right guy? They made an arrest, but if it's not the right guy, it's worse than if they didn't make the arrest at all,
Of course,
because then they stop looking."
now they start looking. And just to finish off my answer a question ago, a lot of the counties upstate, from Putnam and going forward, a lot of them they
They
don't
don't.
a lot of them don't have a unit. No.
Okay.
And
So
another thing too, just really quickly, some telltale signs that a unit is real, rather than because sham unit. Of course, the country sham units
sure, I
exist.
could imagine.
Okay, so telltale signs. So first of all, it's supposed to be led by someone from the defense world. Okay, it's supposed to be independent, walled off from the rest of the unit. The head of the conviction review unit is supposed to have direct access to the DA without bureaucracy in between,
Right.
and it's supposed to have known employees, you know, with a budget. It's supposed to be staffed and with a, but not this. Well, we reinvestigate as needed, and
There should
you
be
know, it
transparency.
should be transparency, right? But also that is your job. You're not juggling. You're not managing sex crimes or prosecuting
You're doing this on the
homicides or
side,
doing
right?
yeah doing on the side. So those are all telltale signs of the
Okay.
of the
Full
unit,
time responsibility to look at those
right?
cases.
Sure, and of course, how they deal with well-known innocence claims, the evidence of which is well known. Looking at how they deal with those cases also is a sign of. Cy Vance, for example, when
Right.
the Manhattan DA had a
Sure.
sham unit, which rejected many claims that ultimately were won in court
He
on
was like
innocence
providing cover.
grounds.
Yeah, we got that bureau, but has it improved?
Yeah, it has. Yes, it has. So, DA Bragg recent his office exonerated Stephen Lopez, a six Central Park Five defendant,
Okay.
and we have the foundation has a case that we're proactively reviewing with that unit now. We're about to start hitting. About to start doing street and we're ready to start doing field interviews.
Right. I think one of those young men is running for office now.
Well, he got elected. That would be
Oh, he did.
Yusuf's. Yeah, that would be
Yeah.
Yusuf Salam.
So just
Yes,
recently, this
just recently he had the election. Yes,
he won.
he won. It's
Hmm.
incredible. I mean, he can't say enough
No.
about Yusuf to bounce back from that. Happy he did 5 years in prison, but to bounce back from that, being 15
Hmm.
and wrongfully convicted of such a heinous crime, and to go from that to now, being a New York City councilman elect,
Wow.
broke that ceiling for the first person nationally to do that, come from being an exoneree. And I was at his election night party, and he uh, came in the venue about a half hour before the official word
Hmm.
uh, came in. So he speaks for about 5 minutes, and he then stops. I mean, it's his moment.
Right.
But he stopped. He recognized me there
Wow.
verbally, called me up, handed the microphone. It was such a
Wow.
gracious, unselfish, wonderful thing. And, I'm really excited because now we have an ally within the New York City Council, and he has a commitment to fighting wrongful conviction. I mean, certainly as a council person, you can introduce resolutions
Right.
calling on the legislature to pass various measures
Sure.
aimed at preventing wrongful conviction. And, he's vowed to walk the halls of Albany with us at certain key
Right.
moments,
And he's
meeting
got
with
street
elected.
cred
And he's got street
because
cred.
of what he went through.
Yes, yes, he did. And, I want to make a political statement right now. I want to, again, call on Governor Hochul to sign the Challenging Wrongful Convictions Act. It was passed legislatively, and she has not as yet signed it. There's been total radio silence on her part. So, in brief, Phil, what that critical piece of legislation would do, it would provide counsel for indigent defendants in post conviction motions. Currently, there is no right to that. Like, I shouldn't have had to write letters for 4 years trying to find an attorney to take my case pro bono. Okay. So the counsel, and the second thing is under bad case law, under People versus Tiger, if a defendant has, say, if you plead guilty,
Right.
and you have a terrible public defender or a terrible lawyer in general, whether public or not, they don't do any investigation. You can see which way this thing is going. They're telling you to plead guilty, and you take the
And
plea.
you do. Right.
And then subsequent to that, you get a good attorney, and you get an investigator, and they find some evidence of innocence. By that decision in People versus Tiger, the court will not consider that evidence. You're barred from arguing actual innocence. You are barred. You cannot argue newly discovered evidence. Your lawyer would be relegated to simply arguing that evidence demonstrates inadequate pretrial investigation, and therefore it's a basis for
But they're looking
ineffective
at your
assistance of
plea as you
counsel.
made an admission,
Right.
as opposed to being found guilty after trial.
Correct. But this law, all we're saying is that the court should consider the evidence.
Okay.
And that the third
Right.
thing, and then I don't want to move on to another
Hmm.
question. The third thing is that anybody who's been convicted of a crime that subsequently uh, becomes legal, like the goes from illegal, so a gravity knife.
Right.
Okay, you would be allowed to go back to court and remove that from your record, so the collateral effects of that conviction, and there's some post conviction discovery built in.
Well,
So that's a
marijuana had a
critical.
lot of those.
Yeah, exactly. So that would be another example. So we
Hmm.
want the governor to sign this bill
Why do you think she's reluctant to sign?
because there's been a lot of pushback on discovery and on bail. A lot of that is from the law enforcement community. I think that a lot of it is fear mongering. So New Jersey, for example, just across Hudson River,
Hmm.
they have automatic discovery, and bodies aren't floating up and down the Hudson River. So I think that the fear mongering is not an accurate thing, but she's got a lot of blowback from those
Hmm.
things, and I think that that's what's causing her to hesitate to sign this piece of
It's interesting
legislation.
because two Democrat legislative,
Mhm.
Democrat-controlled legislative bodies passed it,
They did.
and she's a Democrat,
Yes, she
so
is.
you'd think that she would see it
You, yeah,
for what it's
you,
worth
yeah.
and sign off on it.
You certainly would think that, but but one key point also, and I've said this publicly a number of times, and I'd like to repeat here now. You know, wrongful conviction is a human rights issue. Okay, it's not a democratic issue, although a lot of Democrats are for measures. It's not a Republican issue. It's a human rights issue, and all political differences and ideologies, I think, could be put aside, and we should all be able to agree, no matter what your political outlook is, even independent, not even one of the two parties. We should all agree that innocent people being arrested, wrongfully convicted, and then
Hmm.
remaining wrongfully in prison is a horrible thing. We should all be united against that.
Absolutely.
We should all want to have measures passed to make the system more accurate to prevent and correct those injustices.
Right. Now you were saying about politics. I'm a conservative guy.
Mm-hmm.
I'm a former prosecutor,
Sure.
now a defense attorney, and it shouldn't be like you said, a Republican or a Democrat or an independent issue. You should want the truth,
Yes.
and I would not want an innocent person sitting in a jail cell because it's bad for that person. It's also bad for society because it could happen to anybody.
Yes, it could happen to
Right?
you.
You weren't some bad guy running around the streets. You were just some young kid, 16 years old, who
Yeah.
got caught up in it, and it profoundly. Now I bet those 13 people are probably kind of happy that you took that path, because
Yes.
had you not,
Right.
they probably would still be in jail.
That is true. I do think about the irony of that, but I do make sense of my
Heavy
life,
burden
and
for you.
it is a heavy burden. I mean, I do feel a big responsibility to them, and you know, you have your limitations as well in terms of we're at our level now.
Right.
We're at our peak. Like we've got 13 active cases we're working on now. We have another five that are approved but waiting.
Right.
So it's hard to like wait on the have a waiting list. But if you don't have the resources, and myself and my team were at our the limit, you don't have it. So
Hmm.
that is difficult.
It's funny. I remember the Menendez trial
Yeah,
some
I
years
do
ago.
actually.
Leslie Abrams, that lady with the big hair,
Yeah,
she had that
the blonde.
blonde, and she was asked a question. It's funny because I wasn't an attorney back then, if I'm not mistaken, but I remember her being asked this question. They said, "Isn't it tough to represent a guilty person?" That was the question, and she said, "No, it's representing an innocent person. That's terrifying." And as a defense attorney, that's true. If I have a guilty client, let's say, I work at the best deal possible. I work out a plea bargain. I do what I have to do. When you have an innocent person, I was telling you about that fella that was charged with assault for
Right.
stabbing somebody. It was a self-defense case. I thought about it every night, because if that guy went to trial and lost, he was looking at a long jail sentence, and I knew he had a valid self-defense claim. So when you have, it's the innocent ones. That's why maybe you lose sleep some nights, because this guy's in jail, and you see it up. We read about things in Newsday. You're dealing with it on the street level. You're seeing it.
Yes, it does. It does. It does keep me. It does keep me up at night, and just the fact that these cases take so long, and there's a lot of hurry up and wait as well. You do what you
A
can
lot
on
of
your
yeah, a
level and
lot of
file, and
waiting.
now you wait. So that definitely keeps me up. I think that the hardest thing for me in doing this work is there's a lot of cases where I'm making it's all an educated guess. It's not a
Sure.
hard science. Okay, I believe the client is innocent. There's nowhere to go with the case. There's nothing to do. I have to say no because there's no viability of exoneration.
Right.
Those are the most difficult,
Even if you believe he's innocent,
even if you
because
believe he's innocent.
there has to be an end game. Jeff, I really want to thank you for coming on the show tonight. Some of these shows that I have, like when I have a comedian on or I have even a politician, but this these kinds of issues I find fascinating, but it's real life. It's real because it affects somebody profoundly. It's not just them; it's their mother, or it's their child, right? Or it's one of their relatives. And people like you just do an amazing work. And I can't thank you enough for coming on the show. I wish we could go a little bit longer, but we're running out of time. And very quickly, how can they help you?
Bottom line is that it's unfortunately expensive to work on freeing people. So, if you have the means, or if you work for a corporation that does corporate philanthropy, if you have a podcast, if you're a journalist, if you have can network me. My biggest challenge is I need to meet some people that have capacity that this issue speaks to. So introductions, all of that makes a difference.
Thank you very much, Jeff. You have a good night. Thank you. Look at that.
We did it.
That was
Before you get up, for YouTube, I just want you to look into your camera, and then we're gonna do a just 20 seconds. Just introduce. You're not gonna be on camera because
Okay,
it's gonna
that's fine.
basically.
That's fine.
So, just introduce Jeff, and then just like say, like how you normally do. Attorney Phil Jusino.
look at all this interplay. Yeah.
Oh wow.
Yeah. Michael Levitt. Michael Levitt gave me this. He's an attorney. He was my intern when I was in the DA's office. He's an attorney.
Wow.
Good
Very
attorney.
nice.
Richard Dorino. Michael Levitt. What did he say?
Sorry, really quick, Deb.
So,
I'm gonna start this. When this gets to 20, just keep looking at that camera. When this gets to 20, just to start your say that, I'm Attorney Phil Jusino.
the episode
Yes. So, and then just
Mhm.
so
20.
once they get to the 20, yeah.
I'm attorney Phil Jusino, and this is the Phil Jusino Show. Tonight's episode is brought to you by Big Belly's Barbecue, and my special guest tonight is Jeffrey Deskovic, and tonight's topic is the wrongfully convicted. Welcome aboard, Jeff. Okay. I didn't see all of this.